Previously on X-Men.
Weinstein, Short, Mackinac Matthews, they all had an objective today, was to try and get this case dismissed. And it didn't happen. But you can't get a grade for that. I can't give them an F. I would give them an F if they didn't even try. I can only give them an A if they succeeded. So it's a non-grade. Because at the end of the day, nothing happened. That judge isn't going to dismiss this case. We're going to get the jurors back in and all that stuff and everything like that. And ultimately, all the things that they asked for, they got one that they needed. They need the judge to come out and say, no matter what a judge says, it's not facts, and that we got a new judge and the other judge is gone. That's going to paint the illustration that the judge did something wrong. Well, that's exactly what happened. They dropped a bombshell motion that essentially said, nah, and we'll break it down. State of Georgia versus Shannon Stillwell. Order on defendant Stillwell's renewed motion for fair and constitutional trial. Defendant Stillwell raises numerous assertions of error, impropriety, prosecutorial misconduct, and judicial partiality, which he asserts have resulted in a denial of his constitutional rights to due process and a fair trial. The pertinent determination is whether such events, if they occurred as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of prosecutors. Claim 1. A plague of discovery violations, missing police reports, and Brady violations. Discovery is being addressed. This court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on the case. As recently as the court proceedings on Friday, August 1st, 2024, the court confirmed the state's understanding that Brady obligations include the disclosure of material impeachment items and reminded the state of its continuing obligations under Brady. The state represented to the court that it has fulfilled all its Brady obligations. The court will address remedial Brady action later in this order. Claim 2. Prosecutorial failure to follow court's orders. Making of specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. Any past failure of the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of a denial of defendants' rights to due process in a fair trial, no specifics establishing this assertion and no claim of resulting legal error is alleged. Any potential error stemming from prosecutorial failure to follow court's orders may be addressed on a motion for new trial and/or direct appeal, assuming any conviction. Any specious allegations against defense counsel, counsel for a witness, or lack of candor with the court is, at minimum, extremely unfortunate. These items do not, however, establish a denial of defendants' rights to due process or a fair trial, and the court at present declines to impose the extreme sanction of removal of any offending prosecutors. Claim 3. Improper evidentiary ruling by the predecessor judge. A defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. Peoples versus State. Evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitutional violation, can be addressed in post-trial review. Claim 4. Mistreatment of defendants and their counsel by the predecessor judge. Aside from a blanket assertion, the motion does not detail any alleged mistreatment of defendants. The alleged mistreatment of defense counsel detailed in 9AE and H is not alleged to have occurred in front of the jury, and even accepted at face value would not rise to the level of a violation of defendants' due process or fair trial rights. As to remedies, the predecessor judge has been recused, and the contempt issue outlined in 9H. Turning to alleged mistreatment in front of the jury, 9B and DA, judge has broad latitude in determining how to control the courtroom and directing attorneys to sit down when overruling objections falls within that latitude. This court will give a remedial instruction directing the jury to disregard any disparaging remarks about counsel. Claim 5. Improprieties in and illegality of June 7, 2024 ex parte conference. In open court on June 7, 2024, the prosecution requested an ex parte conference with the court June 7, 2024 transcript. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Kenneth Copeland, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming a right to be present for this June 7, 2024 conference, no one on the defense team objected to the request or sought more information about it, thereby waiving any right to be present for that conference. Whoa. For the proposition that defendant waived right to be present by failing to object after being informed a trial judge is meeting with the jury outside the presence of defendant and counsel. As for topic of this ex parte conference, defendant assigns nefarious intent to prosecutor Love's and Hilton's representations about their interactions with Copeland's main counsel, Jonathan Melnick. The court at this point declines the invitation to so view their representations, but refer the prosecutors to its footnote 1 herein. Defendant complains that comments by predecessor judge during this conference reveal his partiality to the state. Permitting the questionable accurateness of such characterizations, this issue has been mooted by the recusal of that judge from the case. Damn. Claim 6. Illegality of the June 7, 2024 ex parte meeting. On June 10, 2024, at the behest of prosecutor Love, the predecessor judge held an on-the-record in-chambers meeting with Love and standing counsel for Copeland, Caleb Bumpus, June 7, 2024, transcript of ex parte. Following a recess at which time Love departed the meeting, Copeland and prosecutor Hilton joined the meeting. Defendant's motion raises several challenges to this ex parte meeting. Did defendant have a right to be present? Did the ex parte meeting amount to coercion of Copeland's testimony? And did any Brady violations occur? Did defendant have a right to be present? Defendant is correct that this meeting was about more than just parameters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting, before the first break, centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest and with logistics of handling Copeland's testimony with standing counsel. But because these topics were all ancillary to Copeland's immunity grant, the topic of that meeting remained at its core and asserted by the prosecution Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical state of the trial at which the defendant had a right to be present. See Snyder v. Com of Massachusetts. Criminal defendant has a right to be present when his presence has a retaliation reasonably substantial to the fullness of his opportunity to defend himself against a charge, but not when his presence would be useless or its benefit but a shadow. The presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. Defendant is correct that there are differences between the meeting in this case and meeting in King v. State, cited by state. For instance, the meeting in King was to secure immunity for a key prosecution witness. The defense was aware that the immunity hearing was occurring. Here, the defense was not given notice of the meeting, and immunity had already been granted to a key prosecution witness. So the topic was not whether immunity was in the public interest. Instead, its topics were the adequacy of the witness' legal representation and logistics about standing representation, as well as ensuring the witness correctly comprehended the meeting and impact of the immunity grant. What would and would not amount to contempt of the order granting immunity and compelling his testimony, and potential consequences of failure to comply with the order. But the state's reliance on King does not demand that its facts be on all fours. The legal import of King for this claim is that because the defendant's rights are not the subject matter under consideration in proceedings surrounding a witness immunity grant, a defendant has no right to be present for decisions with the tribunal surrounding witness immunity. The fact that here discussions included what testimony would be subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail, even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. See also State versus Lowry. No right to be present at hearing to compel witness testimony pursuant to immunity grant, Chestnut versus New York. Ex parte meeting at trial court's behest between court, prosecutor, and counsel for witness initiated after defendant and his attorney had left the courtroom during a recess at the close of the witness direct examination. and held to ensure witness understood his deal with the prosecution and he was not knowingly incriminating himself and understood his constitutional rights, held to be an ancillary proceeding dealing only with the rights of the witness, at which defendant had no right to be present. Was the witness testimony coerced? Separate from any defense right to be present for ancillary proceedings concerning witness immunity, defendant has a right to a trial free of coerced testimony. Defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable statute of limitations relating to what crimes or crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Copeland into testifying. Webb v. State is the touchstone for evaluating claims of coercion by trial of a witness testimony. Archer v. State provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntarily a witness determination whether to testify. Here, Copeland had the benefit of counsel. The predecessor judge did not, on the whole, use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of the decision he had to make. He explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Still, some of the information provided to Copeland may have been inaccurate. While it is likely that Copeland was not introduced by any inadvertent or other inaccuracy to testify, the cleaner approach is simply to permit this issue acknowledging past inaccuracies, and advise Copeland anew. This is the course that the court has proposed and parties have affirmed its efficiency. Was there a Brady violation? This has been a long-running, multifaceted proceeding. Challenges have been myriad and formidable. Frustrations may have been mounting while fortitude was waning. And a needle in a haystack is not only sometimes difficult to find, but also easily overlooked. The court does not attribute bad faith to anyone on this issue, and yet, as soon as Copeland joins on June 10, 2024, in Chambers' ex parte proceeding, he states, "I have never been truthful a day in my life until I just made this statement right now." Copeland may have little credibility, he may speak in hyperbole, but the fact remains, for a defense attorney, this nugget by a key state's witness is so gold. So when the prosecution not only did not reduce this statement to writing and produce it, but also asserted in court filings that the defense had no entitlement to know the contents of ex parte proceedings, this amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material. The defense now knows of this statement and indeed of all of what occurred during the June 10, 2024 ex parte meeting. The contents of the meeting were ultimately revealed during the course of trial and in time for defense to utilize it. Wow. So the failure to produce suppression of this information does not technically amount to a Brady violation, but the fact that a violation of defendant's constitutional rights have been averted does not. Under these circumstances, provide cause for celebration. What it does provide is cause for sober reflection and an examination of processes, procedures, and approaches that permit it is likely inadvertent but nonetheless serious Brady lapse to occur. Defendant seeks a sanction, the disqualification of state's two-led prosecutors, because this does not appear to the court to have been purposeful violation, but rather negligent overlooking of the impeachment value of Copeland's in-chamber statement. This court does not order their disqualification. At the same time, the court is cognizant that defendant's liberties, as well as liberty of his co-defendants at this trial, is at stake, that the prosecutors involved are knowledgeable and experienced, and this is not the first alleged prosecutorial misconduct in this case. The court therefore orders a remedial measure that the entire prosecution team working on this trial submit to training on Brady and other professional obligations of a prosecutor. This training will consist of a video replay of training on this topic previously presented by prosecuting attorney councils of Georgia. This court will provide the video, and the viewing will occur under the direction of this court. So ordered this 8th day, August 2024, Judge Paige Reese Whitaker, Superior Court of Fulton County.
Now, I thought that the judge was going to believe the cop, and it turned out she ain't believe shit that he said. I want you to watch Shart's questions, how he say that, oh, no, he never talked about no murder. And then the judge sits up there and goes, question him, and then turns out he did say something about a murder. Check this shit out.
Long, good afternoon.
Good afternoon.
I want to talk to you specifically about the off-the-record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I have it mixed up, was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
All right. First of all, the off-the-record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay. And that was before what we're deeming the off the record conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hilton. Okay. And that was to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay. And when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay. And so, all right.
Yeah.
Thank you.
And you indicated that during this off the record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off the record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't see charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean what she said?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yeah. Her statement, her comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, this is me paraphrasing, for something that you did, then knowing that you didn't, knowing we know you didn't do it, then she would see perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point, Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes.
Okay. And that was out of Ms. Hilton's mouth?
Yes.
Okay. So Ms. Hilton specifically, during the off the record portion, referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is in that off the record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
It was both.
killing. Okay, so it was specifically something we know you didn't do, and she also said specifically
Right.
for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hilton, did Ms. Hilton just bring Donovan Thomas that case into the discussion, or did Mr. Copeland say something that Ms. Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hilton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity. So
your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up the Donovan Thomas murder.
Right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to,
Yes.
yeah, we said, I don't recall if it was Ms. Hilton, but Ms. Hilton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Anybody else?
How are you, sir?
How you doing, Mr. Steele?
I'm okay. How you doing?
I'm doing fine. Blessed and highly favored.
Can I ask you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Objection, relevance.
Sustained.
At what point were you initially told that you're going to this ex parte meeting?
Objection, relevance.
I want to know which part he was there for. The beginning part, he said he came with Miss Hilton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you that?
Ms. Hilton, I believe. Yeah. 'Cause of course, we had to escort him over to the judge chambers.
And did you escort, when you say them, who did you escort to this? Say one more time.
Ms. Hilton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you.
You're welcome. Anybody else from the defense?
Oh, I have one other question.
Go ahead.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
Objection, relevance.
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
No. If I understand you correctly, did anyone tell me not to say anything?
One more time, you spoke very fast.
I'm sorry. What's your question? Did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
Mr. Matthews? While Mr. Matthews is making his way over, what is your recollection as to sort of when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall, that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near
Okay.
the end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No.
Did you make any written notes of any of the meeting yourself?
No.
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying before this honorable court, correct?
That's right.
Okay. Did you know this morning before court that you might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
Question. When you spoke about the comment that Ms. Hilton made about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualifying?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything before we charge. But she did mention the fact of I can only speculate, I would use the word, the concern about him trying to take claim for something after receiving free use immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it, or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it. Yeah.
Thank you.
Mm-hmm.
Thank you.
Anything else from the defense? All right, is the transcript before the witness?
She like, I got your ass. Watch this.
All right, is it a fair characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay.
Your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up Donovan Thomas murder.
Right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
Okay, and does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
Yes.
All right. Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Give me just a second. Let me look a little past just to make sure.
Sure.
It happened after.
Okay. If you take a look at the entire rest of the transcript, do you think you might be able to figure out about when that break and off-the-record conversation happened?
I will take a look.
And I mean, you may or might not be able to, but if you can, let me know. If you can't, let me know that as well.
Your Honor, I believe page 52.
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone. Thank you. Go ahead, I'm sorry.
No problem. Your Honor, I believe 52, around 13, 14.
Okay.
When we come back in, let's see. Yeah, I think somewhere around in there.
Okay. And a break is actually indicated at lines 9 through 13 or so. Is that right? Okay.
Right.
And then at line 14, the court remarks, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
Yeah, 'cause
so
that's
it's
near
right
the end.
before that the off-the-record
Yes.
conversation occurred? Okay, thank you. All right. Any other questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. Ms. Love, anything?
Yes, Your Honor, thank you. Chief, Deputy Chief Long, on page 40, lines 20 through 25, when the court refers to comments made to Mr. Copeland earlier by Ms. Love, did you ever hear those types of comments made by Ms. Hilton?
Yeah, Ms. Hilton, yeah.
Was there any time you are aware of that Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Okay. All right. Investigator, thank you. You may step down. Any other evidence? Ms. Love.
She didn't believe him. Bruh, she took the word of Woody over him. Woody said, I always lied, but in this moment, I happen to be telling the truth, and the judge sat up there and ate that shit up. I think that judge knew that he was full of shit, and it was shown. And that's why she got in her questions and all of that stuff. Glanville would have never did nothing like that. I ain't gonna hold you. This judge is fire. A+. Shark gets an A+. Mackin ass math. And I'm not saying maggot like M-A-G-G-O-T. I'm saying mackin like a Mac. You feel me? I don't know why y'all keep confusing that, but whatever the hell. Maybe the subtitles. But yeah, bruh. So basically, what the motion says is, bruh, y'all found out anyway, so it's not really Brady, which I think is a load of shit. But she basically saying, since the trial is going on, that y'all found out Brady material. But in the freaking, what's the name, in the trial of Alec Baldwin, bruh, they found out Brady material and all of that stuff basically later. So I want to know, and I would like to know, how the hell the state of New Mexico justice system is so much better than the state of Georgia. Maybe it's the land of enchantment. I don't know. But either way that goes, bruh, we're going to get to a point in this trial where eventually this shit going to get dismissed. If they keep, like, they can't keep doing this. You know what I'm saying? This can't keep happening. You know, like the dude in freaking Breaking Bad. So I'm looking and I'm like, there's no way, but there is a way. The judge knows that they full of shit, and I think the judge is going to let them play themselves out of their position now more than ever. When she said basically, y'all need a class. Hold on. Y'all need a class. Yeah, y'all need a class on Brady material and how it's supposed to be disclosed and all that. Man, she a head prosecutor. This bitch is responsible for thousands of lives. Like, what the hell? You mean to tell me she got to get an instructional video like she was somebody who broke a workplace, OSHA workplace goddamn violation? Really? And she didn't just say her. She said your whole team. Your whole team don't know how to do their damn jobs. And that's where people are going to start to turn on this judge, because eventually you got to stop giving these people all type of chances. So I think the roar is going to start to come out. I think that it might be Harvey, bruh. Y'all let me know in the comments who y'all think it is. Who's going to be the first lawyer on the YSL defense team to turn on the judge if it continues past Monday? Who? I got Harvey. I don't know, but he just has this thing where it's like, bro, I'm telling y'all how to do y'all stuff. I'm telling y'all how to do y'all shit. And when I say y'all, I'm talking about the judge and the court system in general. He already has the Harvey rule. He has a rule named after him, which basically the Harvey rule says if we all are facing some crimes and we all got multiple attorneys, my objection applies for everybody, and you got to adhere to that. So I think it'll be Harvey. Second in line to be Keith Adams. Then it'll be Brian Steele. Then it'll be Mackin-Ass Matthews. It can never be Loverboy Sharp. I'm sorry. I'll be surprised. I'll be pleasantly surprised. I would come out and say, damn, pulled the shit out of me. I thought they was hunching. But either way that go, bro. The problem, the main problem I see is you giving remedies instead of sitting here and getting rid of information. That's what you should be doing. That's the natural remedy, in my opinion, and the opinion of other lawyers that I already talked to. Yeah, bro, nah, she's supposed to kick out some goddamn evidence. She ain't supposed to be sitting up there saying, go to the back and watch this video. Now, it would be funny if the judge was there like a goddamn teacher with a big-ass ruler stick and pointing to certain parts and giving out tests afterwards. But, bruh, love, for all your attention to detail and how intelligent you come off, you're pretty fucking dumb. I'm gonna be honest with it. I hate to cuss and say that, but bruh, I see why. I thought, man, for a minute, I was like, bruh, I don't like the way that this judge is talking to Miss Love, but she can clearly see Miss Love don't know how to do her damn job. And the rest of us has been saying that from jump. Love don't know what the hell she doing out there. Get her out of the game, coach. She's done. Count her out. Hit her with the Stone Cold Stunner and pin her. 1, 2, 3. No, she ain't done. Hit her with the goddamn people's elbow. No, she ain't done. Goddamn, we can't get the 1, 2, 3. Hit her with a swanton bomb. All right, she's done. And I think that's what's going to happen. Eventually, it's going to be too many motions, too much stuff where they eventually going to do it. And like I told y'all previously, it's going to be death by 1,000 cuts. One of these motions will stick in the future if we continue on after Monday. And I have to be fair about that one. Now, we need prejudice. That's what we need. We need prejudice. We don't need a mistrial and then we restart all over again, bro. This is costing Young Thug millions of dollars. It is. You think Brian's still just doing this out of the love of his heart and all that? Hell no. Bro, no. By the time it's all, if they get a mistrial without prejudice and all that crap, do y'all realize by the time it gets started, a majority of those probation plea deals are done? And if I'm everybody that was on probation that was supposed to come in and testify, I am leaving Georgia. Yeah, I'm going to go to Cali. I'm going to go to Oregon. I'm going to go to Washington. I'm going to go to Idaho. Hell, I'll kick it in Montana. And if it's really nice, I might even go to Iowa or somewhere. I keep saying Iowa all the time. Let me switch that one up. What could I say? Go to Minnesota, eh? So they better be careful because the time is ticking on this stuff. If they keep playing like this, by January of 2025, they all have, if everybody who has completed their stuff has completed their stuff, bro, that's it. That's a wrap. They're not going to beat it. I'm leaving. You ain't finna get me, compel me to testify. I'm going to pull a Birdman Williams and shoot him, hit the dash. And if I'm Rich Homie Quan, boy, you better get the hell out of there too. You better move somewhere else. But your records ain't really selling like that, so I don't know what the hell you're going to do. And ain't nobody buying no features from you. Yeah, I'm dissing a little bit because I don't like, whatever. It is what, I ain't even dissing. You know what? I don't even need to do that because I don't know that man. That man don't know me. So let me not do that, bro. That's showing too much bias. My apologies. But either way that go, they better hurry this the hell up because, like I said, that probation, yeah, that falls off by January 2025. And if I'm any of them, I'm getting gone. But Short raised the issue about something, and I'm going to be honest, he was right. Stay tuned till tomorrow morning, and I'm going to drop it off. 9 o'clock Eastern in the morning, 6 o'clock West Coast time. Bruh, crazy.